Data Hub. For those of you who have not been here, welcome. And for those of you that are returning, welcome back. So I'll just tell you a little bit about who I am if you haven't met me before. My name is Jacqueline. So I work at the Data Hub with an initiative called Open Data Exchange, Canada's Open Data Exchange. So I am the community manager. If you ever have any questions about what ODX does, you can always reach out to me. I put my email up here. Just as a little summary, Open Data Exchange helps individuals and companies access open data by putting you in touch with government or private companies that have data that you're looking for. We also offer other services, but please come talk to me if you're interested in learning more. So I had this slide up at the beginning as well. We have some great companies around the Data Hub who are hiring right now. So we've got Kite, Skywatch, Shiny Docs, and Greenland group of companies. And we have some really exciting Data Hub sessions coming up in the spring. So March 7th, the registration is already open for this one. The topic is using machine learning to detect money laundering. So we've had a lot of interest in a lot of these topics that you see up here. And in the spring, we also have a Mythbusters series on some really popular topics as well. So the registrations will come available. You can always check our website for what's coming up. So today's speaker is Brendan S. Lillis. He's a senior associate at Phillips Lytle LLP. And the topic of the session is data residency and the EU GDPR. So welcome, Brendan.
Thank you, everyone. Apologies for the tardiness here. My drive took about double the time as expected. There was a little delay, but we made it. So I'll just give you some background on myself. I'm an intellectual property attorney in the U.S. I do not practice Canadian law. I practice U.S. law. But the topic today is something that I think both countries are kind of equally dealing with on the same footing. So hopefully I can shed some light for you guys. So my focus is primarily on technology. I have a computer engineering background. I'm a registered patent attorney in the U.S. I spent a few years as an examiner at the patent office in the computer memory art unit. So anything really technology related, computer software related, either on the IP protection side or on the data privacy, data security, and transactional side is where I focus my practice. And certainly with everything going on in the news recently, data breaches and attacks and keeping up with the myriad numbers of data privacy laws, really worldwide, something that's been a big focus of ours recently. And the topic of the day is timely because these are some regulations that really apply to anyone doing business in and around the EU. You're going to have to comply, even if you are not set up there with actual employees in the EU. It's just so brief disclaimer, kind of standard. This does not create an attorney-client relationship, informational purposes, and yada yada. Okay, brief overview of the GDPR. I'm assuming that most people will know kind of generally what it is, or else you probably wouldn't be here. But this has been in the works for a couple of years now, since really April 2016 is when the rules were adopted, and they gave a 2-year transition period, which now kicks in on May 25th. So that date is fast arriving for many people that haven't given this much thought up until recently. And this applies to any and all companies that are holding data of European residents. And the residence is the key term. They don't have to be citizens, so they could be citizens of another country, let's say, that reside in the EU. If you are collecting their data, you are going to have to comply with this regulation. And they did put some teeth behind this. The penalties for noncompliance, at least on the maximum, most egregious end, are very substantial, up to 20 million pounds or 4% of annual global sales. So very significant. Remains to be seen, how strenuously they're going to go after some of these companies, especially initially, and how much that's going to apply, let's say to the smaller guy, the small business owner in Canada, in the U.S., the startup company, things like that. But where we anticipate most of these regulations to affect, what I presume our majority of the audience here today, is in their contractual relationships with bigger organizations. So if you guys are acting, let's say, as a vendor supporting a large company, large organization by processing some of their client or customer data, they're going to seek to push all of these same obligations they have to comply with down onto you. Okay, so what do we have to do? What do we need to know in order to get ready for this? And that's kind of what we're going to talk about today. So first we'll start with the definition of personal data under the new regulation, and this is something that's important because it's a very, very broad definition. It says any information related to an identified or identifiable natural person, so any individual resident, that can be identified directly or indirectly, in particular by reference to an identifier, such as a name, identification number, location data, online identifier, or one or more factors specific to this information, right? So what does that really mean? It means that if you're collecting someone's name, if you have someone's email address, that can be used to identify them. A telephone number could be used to identify them. A social media post can be used to identify them. An IP address is even extended to be encompassed within this definition. Although, in this country and in the U.S., I know we don't generally consider IP addresses to be personally identifiable information, but they do potentially fall into the scope of this law. So it's a very, very broad, wide-ranging definition of personal data. This is generally thought to also include data that is otherwise publicly available. So a common question we get, for example, is on something like web scraping technologies. If you have a business that relies upon gathering publicly available information and you store it in your systems, does that still apply to you? Well, hey, it was already out there. It was publicly available. Still applies from everything that we can tell thus far. Okay? So very, very broad definition. And what this law does, it's interesting. We see data security and privacy laws we have a mishmash of them, really in the U.S. for sure. In Canada, it's more cohesive, but you have what I consider to be a couple of different tiers of data privacy security laws. Some of them go straight to, punishments that can happen if you don't do certain things. Some of them are directed to certain types of security measures that you have to implement. And some of them are more or less specific on that issue. Some deal more at the process level. Some deal, way down at the actual, encryption level. The GDPR, though, that resides at kind of a higher tier up and really deals with the rights of the individual data subjects. So that's really what the genesis of the law is. They are defining really consumer rights. People have the right to certain types of things under this regulation, and that leaves the individual companies that are collecting the data to determine how they best want to comply. So you do have some wiggle room with respect to that, given the types of data you're collecting, the scope of your data collection practices, and we'll get into a few of those things. So a couple of the rights that I guess we'll highlight that we'll want to make sure that any company that might be collecting this data is focused on. One is breach notification. And that's something we should generally be familiar with anyway. I think most countries, even here in the West, we have various different breach notification laws that we'll have to comply with. Generally, depending on the category of the data that we collect. But now this is going to be extended to all personal data, and it's a fairly onerous obligation. Within 72 hours of becoming aware of a breach, you're required to report to a data protection authority. This goes to whether you are the controller of the data or a processor of the data. So if you're a processor, obviously you might not have direct access to the end consumer if you have an incident, but you are obligated to the same reporting requirements with respect to the controller of that data. And one thing you might notice is I do prefer using the word incident and not breach. I call breach we refer to it as the B word. The use of that term has potential legal obligations associated with it. So oftentimes, in handling a lot of these instances where there have been incidents, upon further investigation of the incident, you may or may not determine that there was actually a breach, right? So oftentimes it's hard to tell whether you've actually suffered a breach or not before performing some investigation. So one thing I will say with respect to breach notification is that one of the most important things to have in place in your company is an incident response policy that will dictate how you guys respond when you see something fishy going on, right? And the immediate response should not be, the building's on fire and we need to go notify anyone and everyone immediately, let's say using standard forms that you might find online or things like that before conducting a full investigation, right? So it's important that you have the plan in place that allows everyone to calm down, take a step back, really conduct your investigation to actually determine whether you've suffered a breach or whether you've just had some other incident that does not rise to the breach level. And that might vary depending upon the specific types of categories of data you're dealing with, but that's just something that I highlight. People are often too quick to jump and potentially make admissions that might get themselves in more trouble than they otherwise would have been in. The right to be forgotten is probably one of the things that's most associated with the GDPR. I feel like I've heard many references to the law itself as the right to be forgotten, and that is certainly one central component to it, which basically says that if someone whose information you are storing comes to you and says, I want you to get rid of it, then you have to comply with that. So that can be difficult, especially in established companies that have already collected lots of data. Lots of companies have, let's say, archiving policies in place that might automatically create backups of this data and store it, in a cold storage system. That's something that you might have to deal with. Certainly moving forward, you have to have some mechanism in place for allowing someone that asks or withdraws consent to have their information removed from your system. Similarly, there are a couple other rights that individuals have that kind of parallel the right to be forgotten. One is the right to access. So if someone comes to you and says, hey, I've updated my email address, can you please update your records accordingly, then that's something you're actually obligated now to do under the law. So having some type of policy procedure in place, let's say, whether it be a contact address that someone can contact your company and say, look, please update my information. That's something that is now going to be required under this new regulation. Additionally, right to access includes the right to individuals to see what data you have about them. And so if they say, please give me everything you have of me, let me know what it is, that's something that they're entitled to. Now this kind of ties in, with something not on the slides, but that we get questions on a lot, and that's with respect to data aggregation. Okay? Can I take de-identified data and store that without falling under the guise of this regulation? And the answer to that is a qualified yes. My nice lawyerly answer. But generally speaking, if the information is sufficiently de-identified as you cannot tie an individual back to that data, and it's stored separately in your systems from data that might be used to identify that person, then that is something that would fall potentially outside the scope of many of these regulations. So de-identified aggregate data, still good. Right to data portability is another one of these that kind of ties in with the last couple. And it essentially says that if someone wants to change vendors, let's say, and you have a lot of data about them and they want to move to a new company, then they have the right to request that you provide them the data in a format that's easily provisible to the second company. Okay? So in this case, we find many instances where, for example, companies will have proprietary databases that they keep their data stored in, either proprietary formats or either grouped together in certain ways as to establish relationships that the company considers some type of trade secret, some type of proprietary method, proprietary formats. You need to have a way now to extract that data and provide it to either the individual requesting or to the third party that they request you to transfer it to. So that's just something that, if you don't have that capability currently, you're going to have to develop that at some point. Data protection officers, this is a new role, and this can be difficult to track all these different titles that you might have in your company. CISO is another example that we see in the U.S. a lot under some financial services regulations. Chief Information Security Officer. You might have another guy that goes by the title of Data Protection Officer. Those can be two different roles. Sometimes they're the same in smaller companies. So the GDPR establishes this position called a Data Protection Officer, and essentially says that you must appoint a DPO in the case where you have regular and systematic monitoring of data subjects on a large scale, or wherein the entity conducts large-scale processing of special categories of personal data. We'll talk about special categories in a second. But it's good to note that some of these qualifiers, what is large scale, what is regular and systematic monitoring, these are the types of things that are really open for interpretation under the current regulations. So no one really knows what constitutes large scale and what doesn't. A hint as to that is in an initial draft of the GDPR, the large scale or the mandatory data protection officer appointment was only mandated on companies with more than 250 employees. And then they apparently came to find out that the number of employees your company has doesn't necessarily dictate the amount of data that you are necessarily processing. So we tend to take a more conservative approach with respect to whether or not you need to name a DPO. Better to err on the side of naming one than not if you are in the business of collecting, processing personal data. Now, this person doesn't have to be a new hire, for example, so you can potentially appoint someone that is existing at the company as your DPO. You can also hire third parties to act as a kind of an outsourced DPO if you want. Really depends on the complexity of the processing that your company handles, on whether or not which one would be recommended, number of resources you have, but at the very least, it's advised that you do appoint someone that has knowledge of this field. You wouldn't want to appoint someone with no really knowledge of data security, data privacy as your DPO. You're going to want to appoint someone that has at least some experience or some interest in getting up to speed relatively quickly and dedicating some time to this. So you saw earlier we mentioned these special categories of personal data, and a lot of these will coincide with what we understand to be special categories now. So certainly, personal health information is going to be a special category of data. Children's information is going to be a special category. But then we have some additional things as well, and this comes into especially some of the companies that are involved with scraping or advanced analytics or big data. Things like racial or ethnic origin, political opinion, religious beliefs, trade union membership, genetic data, biometric data. These are all things that weren't necessarily called out under previous regulations, existing regulations that we're familiar with, but now are explicitly being called out. So if we are handling any of these special categories of data, then we need to be extra cautious and really make sure that that our compliance mechanisms are locked up pretty tight. Okay, so something I want to focus on with this talk, in addition to just regurgitating lots of information to you about the law and the regulation, is really comes down to the practical nature of what can we do right now. We're a small company, we don't have unlimited resources to spend on a huge compliance audit, only to be told $20,000 later that, oh, you have all these giant gaps and you need to do something to get into the compliance, but they don't give you the roadmap to how to do it, right? So that's something that we see fairly frequently now. So really the first thing that you can do internally as a company, and this is where a lot of these compliance audits begin, is conduct an internal information audit. and I like to refer to this as data mapping. This is really going to be key because you don't know to what extent you might be liable under these regulations until you know actually what you have, right? So that's really the first step. What do we have? And that begins, we can ask some certain questions to help us try to develop this data map, right? And this can even be done in an Excel spreadsheet and in a Word document, right? We ask things like, well, where is the information coming from? Are we getting this information from end users, from our customers? Are we getting information from a third party? Are we just acting as a processor for the higher data controller that has that end user relationship? And then once we get it, what do we do with it? How is it processed? Do we right now store that data forever? Do we have any type of retention policy with respect to that? Who has access to that data? Can the secretary, that has really no reason for accessing this data, just get into our systems and log on and have access to everything? And what is the information used for? So we'll see going forward that we're going to need to tie in the actual purpose of the collection of the data with our use of it. So it's no longer free reign that as long as we got it in an okay basis, then we can use it for whatever we want. No, we're going to have to actually now tie in explicit uses of the information with the purpose for which it was collected. Okay? And the more we can document that, the more we can keep track of these purposes, the better shape that we're going to be. So once we have kind of the information that we know is coming into our system with respect to personal information of EU residents, but really this is good practice for all of our information that we're collecting. We're only going to see these laws kind of mimicked and apply elsewhere around the world. This is just the first of many coming, most likely. Then we can start to categorize that data. Are there any special categories that we have to worry about that should be handled separately? Do we have a data aggregation practice that we should consider separately storing that information from our personal information? We can start determining what format is our data stored in. We know that we're going to have to eventually comply with requests to transport or access this information. Do we have the capability of providing it in a commonly readable format? Where is this data stored? This goes to not only stored internally in our systems, as far as it's stored on this system or that system, but where in the sense of geographically speaking. So, for instance, are we using a third-party cloud vendor that might be set up in a different country or overseas? Do they have servers located at some place that this data is being transferred to? If that's the case, then we're going to want to make sure that we pass along any of these obligations that are imposed upon us over to them. Right? Bless you. Who is the data transferred to? Right? Are we the controller of the data, and do we use processors for that information? So, for example, if we use third-party credit card companies to process financial information that we obtain from a European resident, then we're going to want to make sure that that third-party payment processor is also compliant with these. We're going to want to make sure that our contracts with those vendors have sufficient language that protects us in an event that they have a problem, that they have a hack, right? So then, once we have our collection of data, we have our data map, right? We know what we have, where we store it, what format it's in, all these. Then we need to assign a legal basis for the collection of that information to each category of data that we're collecting, okay? And this is probably one of the more difficult parts, can be one of the more confusing, but we'll try and keep it relatively simple. There's really two main categories I think that most of the companies here are going to need to worry themselves about. And the first one has to do with consent. And this is really a big one. So pretty much gone are the days that if you make a sale, let's say to an end user, and you collect their email address as a result of that sale, so where to send them an invoice or a receipt. Now all of a sudden, before you would want to just sign them up for your newsletter, let's say, right? And now they're on your list. They're on your mailing list. Well, if you didn't get consent for that specific purpose up front, now that's in violation of these regulations. Okay, so again, this goes back to tying the purpose of the collection with the actual use of that data. Okay, so consent is a very important thing, and the nature of obtaining consent is also a little bit tricky and convoluted, and we're going to go over that as well. But that's certainly a big one with respect to the collection of lots of information, obtaining consent up front. You sign up for my website, and I'm going to give you some access to some things behind the scenes. In exchange, you give me a name and email address, maybe a mailing address. Are we going to? Everyone's familiar with the click wrap agreements, right? The little checkbox that you have to check. When you sign up for something online, I think it has the link to the terms and conditions or the terms and conditions and privacy policy actually displayed. Everyone just clicks through and no one reads them, and you go about your day. But those things now are very important to have, really tied up, buttoned up with respect to disclosure, with respect to, talking about how you're going to be using this information. And the method of obtaining that consent is also going to be important. I don't know if people are familiar with the difference between a click wrap agreement and a browse wrap agreement. Browse wrap would be something that basically the checkbox is already checked, or there is no checkbox, right? So when there's not, it can be very difficult to prove that you affirmatively obtain consent from the end user. Rather than if they actually have to check the box that says, I read and agreed to the terms and conditions, well, at least you can show something that they took a step to acknowledge that they were agreeing to something. And at least in the U.S., that's been held as creating an enforceable contract, and that's something we'd also recommend as a best practice with respect to obtaining consent online. Contracts. So contracts are probably the other big method that companies are going to have to worry about with respect to assigning a lawful basis for obtaining this information. And so essentially, if we don't have a relationship with the end user, with the end customer, well, how can we obtain consent from them? You can't. So we're relying upon some third party to obtain that consent for us. And if you are a vendor, let's say, just as these third-party companies will look to push these regulations and obligations down on you, at the same time, you want to put at least some of the onus back on them and make sure that, for instance, they represent and warrant that they collected this data in compliance with all relevant obligations legally. Okay, so they complied with the consent requirements of GDPR when they obtain the information before they pass it to us. Okay, and we'll talk a little bit more about reviewing contracts in a little bit. Some other lawful bases for collecting, processing personal information that we'll breeze through a little bit quicker because they'll probably be less applicable, but still good to know at the same time. If you have a legal obligation to collect that data, such as under a court order, then that is sufficient. If you have what's called a vital interest in that information, and this is something that has a very, very high bar, so we're talking about life or death type scenario, then you have a lawful basis for collecting and processing that information. If you are doing something with respect to one of the governments in the EU, if this is a public task, then that's going to be a lawful basis for collecting and processing the information. And if you have what's called a legitimate interest in the information, this kind of ties into some of the other ones with respect to public interest, with respect to legal obligations. If you are a public authority, for some reason, if you have a contract under a public authority, then you might have a legitimate interest in that information. But this is also kind of a high bar. And again, with respect to any of these, this is why it's so important in our data map that we really identify the different categories of data, because we might have different bases for different categories, right? So just because we might have a lawful basis for one set of data does not mean that we have a lawful basis for another set. And again, the basis needs to be tied to our use. So just because we have a legitimate interest in some public data that we obtain does not mean that we can then use that data for something other than the purpose for which we were hired under the government. if that makes sense. So going back to the compliance with the consent requirements, which I think will be an important one for everyone to focus on. The definition of consent under the regulation is any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement. Okay, so again, going back to the click wrap, browse wrap type situation, this clear affirmative action is something that's definitely new in the regulation and in obligations upon data processors. Mere silence or failure to object is not going to be considered permissive anymore. And then these other terms all kind of carry their own weight. So it's important that we discuss them one by one. So freely given. If the data subject has no free choice or is unable to refuse or withdraw, it will not be deemed to have been freely given. Okay, so again, if you do not have a privacy policy on your website that you're collecting email addresses through, then there's no way for them to give consent because there's nothing to give them for them to give consent to. That's not going to be freely given. Okay. If you have something that's performance of a contract or service is conditional upon consent, which is not necessary for the performance, then that's also not consent. So again, this goes back to if you want someone to sign up for your mailing list, right, and you collect their information online, and the reason you're collecting it is to provide them a service. So we're going to send them our product, and we need to know where to deliver it, so we're collecting information. But we also want to sign them up for the mailing letter. We cannot make that signing up for the mailing letter conditional upon the fulfillment of the contract. Okay, so we can't say anymore that you have to sign up in order to get services from us. Okay, so that would actually be potentially 2 checkboxes. Okay. The consent must be specific. So again, this goes down to exactly the nuts and bolts of how that consent is obtained. So really it's linking every process that we are going to use with respect to their information and disclosing that. Okay, so that's what we mean by specific. The consent has to be informed. So the data subjects should understand the extent and activities to which they are consenting and be aware of the identity of the data controller and or processor. Okay? So if we are a data controller that is merely collecting information from end users and then using a third party to process lots of this data to perform analytics, let's say, we should disclose up front who those third party processors are. So these people know they can research them if they want. They can make informed decision on whether or not they want to allow that information to be passed along to that specific third party. The consent must also be unambiguous. So again, the affirmative action of checking the box versus the box being pre-checked or non-existent. And also having a method to track that, right? So it doesn't mean anything if we have the box that people check, but there's no way for us to go back and prove that it was ever checked, right? So having some type of policy in place internally with your IT department, with your web guy that saves this information and tracks, okay, look, on July 24th at 4:24 p.m., person X checked the box, and there it is. There's our proof, and we can go back to that. So electronic requests must be clear and concise, and the consent must be explicit when it's relied upon for processing sensitive data or cross-border data transfers. So 2 key terms here. Explicit consent. This is another one of those terms that's is really not defined what explicit means. So it's kind of up to you, up to everyone to make sure that you can provide reasonable and defensible evidence that the consent was explicit. So the more information, the more proof, the more documentation, the better in that case. And then cross-border data transfers. This is certainly something that's very likely applicable to companies operating both in Canada and the U.S. It's very likely to be the case that this information is going to be transferred across borders. Now, that's something we'll go over with in a second as well with respect to contracts. We know that so for instance, in the U.S., it's a bit more of a contentious relationship with the EU, and we have these safe harbor mechanisms in place. There's something called Privacy Shield in the U.S. right now, which you can certify to as a company. That governs, grants some sort of safe harbor between, from EU regulations for data that is transferred out of the EU into the U.S. There's no similar safe harbor mechanism in place with respect to Canada. Canada is currently on the deemed adequate list for Europe, and then there's about a dozen countries or so that are on that list. But that was also corresponding with the prior regulations within the European Union as compared with the PIPEDA regulations here in Canada. So that's just something that you're going to want to monitor going forward to the extent that you are transferring data out of the EU into Canada. And consent can be withdrawn at any time. That's another key component. Is just because we gave your consent, someone gave their consent today, doesn't mean that we necessarily have it for all time. Okay? So we have to have a mechanism for allowing people to contact us. This might be the email address for your data protection officer, for example. Someone says, I withdraw my consent for receiving your newsletter, then that's something that we'll want to comply with and have a mechanism for handling. So there's this concept of data protection by design kind of sprinkled throughout the GDPR. And this is essentially says that you have to build in protection for data from the ground up. This is something you have to be thinking about, really right from the get-go. And especially for startup companies, we'll often get questions on, this is just too onerous for us to comply. We don't have giant budgets for IT teams to build all these systems in place. How are we supposed to comply with this? And the answer really is, for all intents and purposes, it's kind of the cost of doing business to some extent, right? Now there are degrees of security measures that you need to take as a company that scale with the sensitivity of the data, with the amount of the data that you're collecting and processing, right? So you don't need to have the security of a Fortune 50 company when you're a small startup, generally speaking, but at the same time, you need to show that you've put some thought into this, right? And you'll hear me kind of sprinkle throughout this. As an attorney, what we're looking to do is put our clients in reasonable, defensible positions, right? We know that every best practice in the security industry is just not feasible for every small company and even for every large company. But we want something that's defensible. So we want things like documentation that goes to show that you guys have thought about this, that this wasn't necessarily just an afterthought. So the more and more documentation that we can build up in support of our efforts to show that we, really were thinking about security from the beginning, then the more defensible position you're going to be in the event that you do have an incident. And that's really our goal at the end of the day. So with respect to data protection by design, those processes that we have in place, those are going to go a long way to showing that we gave this some thought. One way that we can determine, perform let's say a gap assessment, in addition to this data mapping that we already discussed, there's this notion of a privacy impact assessment, a PIA. And this is something that's generally been applied to governmental organizations. So, for instance, I think if you go to the FTC in the U.S., it lists all of their privacy impact assessments, and there might be 30 or 40 of them that are available online. So you can see the steps that they've taken to conduct their own internal audit with respect to all this information. So something like that can be a good resource. And a privacy impact assessment is actually required for certain very large-scale companies under the GDPR. Unlikely to apply necessarily to smaller startup companies explicitly, but at the same time, if you're interested in a set of best practices, so to speak, the real heavy-duty self-audit, if you want to go through that process and see how deficient or up to speed you might be, that's something to take a look at. And that's something that you can readily look up online. Be many different templates available, oftentimes categorized by the type of data that you're storing and processing. So again, you have flexibility here. At the end of the day, we just want to make sure that we conduct some type of self-assessment. Okay, have an idea of where you're at. If you need some assistance with performing that initial gap analysis, there's tons of service providers out there, tons of consultants that can help you out. There's a very wide range of consulting services that are available. So I will say, at least do your research to some extent. Us as attorneys, as a law firm, that's something that we do get into. We do provide gap assessments, gap analyses for clients, but that's probably not what I wouldn't recommend necessarily that you run to an attorney for that piece. Where we really, I think, kind of fit in best is more that icing on the cake. So you guys do as much of the legwork, especially from the technical side, from the security side, from the risk assessment side as you can yourselves based on a lot of this information. And then we come up and we'll, do that finishing touch of, tweak your policies here and there, make sure that you're not, over obligating yourself to things that you don't legally need to obtain. Make sure that you don't go too far. We definitely don't want to put burdensome obligations on ourselves if we don't have to. But at the same time, if we're deficient in a place here or there, that's when we would look to fill in those gaps, and then hopefully that ultimately keeps costs down. Because that's really the important thing at the end of the day. So it's really essential that you do have though some type of strategy. These policies and guidelines that you have in place that we're going to talk about in just a second. And I'll try and be quick for people that might have to get out by 1 o'clock. But just be aware that this is something that's that you really can't ignore if you're going to be doing business, especially with respect to the EU. But really, any type of collecting, processing data. There are a number of other regulations based on category. But even with respect to storing personal information nowadays, even in Canada, in the U.S., there's no central regulation. It's more of a state-by-state analysis. So, there's 50 different states that might have 50 different types of rules and regulations to comply with. So, you do need to, get a handle on this really right from the beginning if you're going to be processing data. We talked about kind of the tiers of obligations, legal obligations, and best practices that are out there, and we talked about how the GDPR is really this tier of rights of individuals. It's at that level. Oftentimes we'll get the question of, well, okay, great, I'm not a technical guy. How do I go about actually complying with these things? How do I direct my IT guys? What set of standards should I even meet? What qualifies as a best practice? Well, here are just some, and there's many out there. These are just a couple of examples that are not, conclusive, but certainly, form a good starting point for anyone that is interested in this stuff, especially from the IT technical side. NIST, this is an organization in the U.S., National Institute for Standards and Technology. They published a publication, 800-171, that governs the control of unclassified information. So basically, if you are a vendor of the U.S. government dealing with unclassified information, which is essentially anything that's not classified in the U.S., right? You are now actually under the new regulations that just went into effect at the end of 2017, obligated to comply with these NIST requirements. And they're fairly comprehensive. Might be 80 or 90 pages of really from at the process level of what you need to have in place. So that's definitely a good starting point for understanding what data protection by design actually entails. And kind of coinciding with this NIST publication, we also sometimes will recommend that you take a look at the Center for Internet Security's critical security controls for effective cyber defense. This is a nonprofit organization. They publish updates to this policy every couple of years. This is available online. Both these are available for free. And the CSC really operates down at a lower technical level, and it maps pretty closely to the NIST standards. So the NIST might give you an overview of actual process. You need to have access controls in place. And the CSC might delve into, okay, based on the sensitivity of the information, this is the type of access control that you're going to want to have. So that gives you both process and both technical as far as example best practices are for what's out there. So those are some resources for you. And again, if anyone's interested in these slides at the end, come see me. We can make sure that they get in your hands. So again, from a practical perspective, what do? How do I comply? All right. So, we're taking data protection seriously. We got our IT team, they're doing all the encryption and access control and all that. Okay, what's the next step? How do I make sure I'm compliant? Practical level. So we talked about that data map. In that data map, that's going to allow us to conduct our risk assessment, allow us to determine whether, we can comply with these data access, data portability, right to be forgotten, right? Well, it allows us to show, man, are we really keeping that information forever? Well, why? What's the purpose behind that? If you don't have a purpose behind information that you've obtained over the years, get rid of it. It's only a risk at this stage for you guys to hang on to that information because this is more potential liability in the event of an incident. Okay, so beyond that, a couple of key pieces that everyone's going to want to focus on. Update your privacy policy. Okay, so this is going to be where you obtain consent, how you obtain consent by disclosing to the public, how you're processing their information. Okay, what categories you're collecting, who you're sharing it with, how long you're keeping it, how you contact someone in the event that you want to access. Okay, and we'll go over some privacy policy best practices in just a sec. Update your incident response plan. So again, make sure that we have a policy for complying with this 72-hour notice obligation, in addition to all the other myriad breach notification obligations that we might have to comply with. And then contract negotiation strategy. We touched upon that for just a minute, but understanding that companies that we do business with in the EU, if we're going to be processing their data, they're going to be looking to pass along many of these obligations on us. What is an acceptable level of risk that we're willing to take on with respect to that? And what should we be looking to push back? Whether it's on our vendors, what should we be looking to flow down to them? Is it going to be a blanket statement, rep and warrant that you compliant with GDPR? Is that enough? Is it, rep and warrant that you guys have your own policies in place, privacy policies, information security policies? Do we want to see a copy of those? Do we want to drill down another level and require that this company, their employees update their password every 90 days? So those are the types of things that you can discuss based upon the sensitivity level of the data that you're collecting and how onerous of obligations that are being placed upon you that you might want to pass down. But certainly, contract review is going to be a key component of compliance and risk. So your privacy policy, this would be generally published on your website, privacy statement, privacy notice, other terms that we've seen it. Just have the word privacy in there somewhere and have it published and publicly available. It's got to be written in a clear, concise fashion with plain language. This has to be really non-legalese in a way that a child can understand. In particular, if you're collecting personal information of children, then they actually absolutely have to understand it. So oftentimes this can be, we see even privacy policies and privacy notices that have two sets of terms side by side. They'll have the legalese that kind of, limit your liability as much as possible, but then a high-level description of what that long paragraph says right next to it. So that's one way of complying with these requirements that we see a lot now. Certain types of information that should be disclosed in your privacy policy. A lot of it is the information that you're collecting in your data map. So the identity and details of the controller and processors, contact information for your DPO, disclosing what your interests are in collecting this information, what categories of information you're collecting, and what you're doing with it. How are you transferring and storing that information? Are you storing it in the EU? Are you transferring it to a third-party cloud provider that has servers in the Cayman Islands? Well, that's something that you might want to disclose because people now have an interest in knowing that, and in certain cases, you're obligated to disclose that. let these people know that they also have rights. So they have the right to access. They have the right to be forgotten. They have the right to update their information. And in the privacy policy, you can have instructions for how they go about doing that with you. It also can be helpful to disclose if you are collecting and processing data under one of those other categories outside of consent, to just have that information also included. So this privacy notice, privacy policy should be provided to people at the time of collection. And if it's not provided at the time of collection, for instance, we're a processor processing data that we have access to contact these people, for instance, that we send them a copy of our privacy notice really as soon as practicable, generally within 1 month of collecting their data. But this goes to that consent checkbox. I agree to the terms of privacy policy. Have that displayed, get it right off the bat. It would be a best practice. Real quick, so I save enough time for questions here. Incident response plan. Again, let's make sure we update to comply with the 72-hour requirement. Let's really make sure that, I guess some of the other obligations that we'll touch upon, real fast is, that there is an obligation to restore availability and access to the information as soon as practicable. And in addition to the notification of the Data Protection Authority, you also may have to notify customers directly. And again, what I would say, with respect to these notification requirements, it's not recommended that you do this without really consulting with an attorney first. And that should be part of your incident response plan. And I don't say that to drum up business. I say that because it's just too easy to make a mistake with respect to possibly admitting to things that you either might not need to admit to or that might not have ever happened. A lot of times if the investigation has not been thorough and you go reporting and notifying, you might be opening yourselves up to unnecessary liability, and you might not have ever had an obligation to notify in the first place. So definitely check with legal before you go and respond if you think you've had an incident. In addition to legal, you want to make sure that your executive team is involved, the IT team is involved. You have a PR. If you have PR people, if you have marketing people, that they're going to be involved. To the extent that you have these people internally working for the company right now, well, let's make sure they're included in our plan. To the extent that we don't, well, let's have a list of vendors potentially at the ready. If we have a relationship with these companies already, that's great. Let's get them in the plan potentially. If we don't, let's maybe do a little research off the bat so we're not scrambling. Oh man, we need a PR firm to help us craft our message for how we're going to respond to this. You don't want to be looking for that company and researching PR firms, the day of an incident, right? So have that information at the ready. Have that network of vendors to engage with, perform dry runs. This is something that's very illuminating, and that's something we do fairly often is these, tabletop exercises. So companies have their incident response plan, right? And the only people that have read it are the two people that drafted it, right? And then it just goes and sits on a shelf, and that's it. Oftentimes we'll see incident response plans that are only stored electronically. And then all of a sudden the company's hit with ransomware, and they can't access the response plan because it's encrypted, right? So, have a physical copy that's actually printed out, right? And test it. You wouldn't believe that, we got this great plan in place. We have all these procedures. We know exactly what to do. And then you get into a dry run situation, and it turns, I thought that was your responsibility. I didn't know I was supposed to do that, right? When you get the people actually in the room and you play out some of these scenarios, it could be very helpful. And then again, don't burden yourself with unnecessary obligations. If you only have certain categories of data that require a 72-hour breach notification response, and you have other categories of data that require a 30-day notification, well, don't put it in your policy that you're requiring the company to comply with 72 hours across the board, right? Don't place unnecessary obligations upon yourself. Don't say things like, we subscribe to the highest level of security standards, and data protection is the most important thing to our company, right? That's gold for the attorneys on the other side that are going to have that policy in litigation when you guys have an incident, right? So do what's legally necessary, what you're legally required to do, and if you want to do more as a best practice because you're a good company, then do that, but don't have it written down as the standard in your incident response plan, for example. Very quickly, contract negotiation strategy. Monitor the adequacy status of Canada with respect to the GDPR, with respect to EU regulations. That's something that we would not be surprised gets revisited sometime in the near future with the implementation of GDPR. A couple things that you can look to with respect to the transfer of data outside of the EU. There's these things called the model contractual clauses. These are things that do grant some level of safe harbor with respect to that data. Just be aware that they do obligate you to comply with a number of potentially burdensome obligations. In addition, they also generally submit you to jurisdiction within the EU. So if that's not something you're interested in, then you might want to look elsewhere than the model contractual clauses for negotiating your contracts with vendors. One potential method, especially if you are using, say, a cloud storage provider located in the U.S., then compliance with Privacy Shield, even as a best practice, even if you're a Canadian company, might be something that's worth looking at, and that might be enough to get a company not to impose the model contractual clauses upon you. EU Privacy Shield provides a mechanism for arbitration that you do have to subscribe to, and you do have to pay probably an annual fee to get. But depending on the amount of data transfer and business that you're doing in Europe, could definitely be worth considering. At the end of the day, it's how much risk are you liable for? How much risk should you look to be passing on to third parties as much as possible? And how much risk are you comfortable with? And that's going to be a give and take depending on your bargaining power, your negotiating position. But having some type of cohesive strategy for how you're going to negotiate these contracts, what you're willing to live with, what you're not willing to live with, can be very important. And again, as a law firm, this is just a quick pitch for us. We are here to help. We really kind of run the gamut as far as myself personally. I'm more on the side of pre-incident, so developing policies, running tabletop exercises, doing gap assessments, on the technical end, bridging the gap between IT and higher level executives. That's kind of where I live. But we also do, as a firm, incident response. Really, during incident, we have teams of vendors that are lined up that are ready to respond. Really day of, we have a crisis hotline, 24/7 number that goes to a cell phone. That we respond in the middle of the night to incidents, all the way to post-incident, dealing with notification, dealing with government regulations, government investigations. We kind of run the board with respect to that practice. So with that, now that I've run a few minutes over, I want to leave time for questions, and also anyone that does not want to ask a question in front of the group, I totally understand that, and I would also even advise caution to some extent. You wouldn't believe how ready people are willing to share their lax data security practices in the room. So if anything that you're uncomfortable with in front of the group, certainly save it till the end. I will be sticking around for a while. Please.
In relation to HIPAA, would you say is HIPAA a superset of this in the sense that if you're complying with HIPAA, you're probably covered, or are there differences between the two?
So the question is with respect to HIPAA, and if you are compliant with HIPAA, do you think you're compliant with the GDPR, and maybe vice versa? So again, this gets into the categories of information, right? So for instance, we might be compliant with HIPAA with respect to protected health information, as that's defined in the U.S., but if we are not protecting all of our data in the same way that we do under HIPAA, then we might not be compliant with the GDPR because of its broader interpretation of personal information. So that's definitely one thing to keep in mind with respect to those two. As far as a best practice for security levels, so under HIPAA, there's a clause called high tech, and that governs the protection of electronic personal information, personal health information, or protected health information, whatever so many acronyms. So compliance with high tech will generally get you a good portion of the way, if not all the way, with respect to technical obligations of security and protecting that information. That doesn't necessarily, again, mean, for instance, that you are able to comply with data portability. So if you are storing your personal protected health information in a proprietary database, which we often see in the health field, and you have no right or no ability to easily port that, let's say, outside of the organization to a competitor, then that's something we might need to look at.
With your face being a source of biometric data, are there obligations to social media platforms to be able to deal with sort of the public sourcing of photos that may have your image in it as it relates to some of these laws?
So the question is with respect to biometric data and the obligation of, say, social media platforms to comply with some of these rules and obligations with respect to photos that just might be sourced. How do you obtain consent, right? If your picture is in the background, even though you might be identifiable within that. The only thing I can say with respect to that is if you are the one collecting and storing, if you have a social media platform, then you should be, should be looking very closely at your the use of that type of information by the company. So to the extent that you might be using software to identify people in a picture in a way that they did not explicitly consent to or without their permission, then you're going to be in a world of trouble under this law. And this is something there's just a recent case in Germany where Facebook took a beating, right? And we'll see how that ultimately plays out. I think the story is not fully written there, but at the same time, the definition of personal information is so broad that anyone that uses Google Analytics on their website is going to be collecting IP addresses. To the extent that you have European residents visiting your website, well, now you have potentially personal information on your system. Now, if you are not actually doing business at all in Europe, and it's in your policies that you advise people from Europe that we're not complying with this because we're not doing business there, and that's fine. But say that that would be advisable now. And to the extent that you are doing business there, be aware that that's something that might fall under the guise of the law. Good.
So we have data for the last 7-10 years. What do we do now about consent?
So the question is consent retroactively. To the extent that we've been collecting data, we have all these databases for the last 7 or 10 years. What do we do now? So certainly best practice to identify if you had a legal basis under the law to collect that data originally. So if this is a customer that you needed their address to send them information, and that's why we kept the information, and we're storing the information for X number of years, so we know we have a history of who we sent stuff to, and that's important for our company. At the very least, let's get all those policies in writing and get them published. Okay, if we can associate the use of that data with a lawful collection under the current law, so for instance customers, then we probably don't need to go back to them again, right? But if we're using that information for something other than the purpose it was originally collected for, then that's something that we would advise you go back to them and try to obtain consent for.
What about for click-through consent? This is a B2B case. Is it sufficient to link to privacy policy that has the details? You don't need to enumerate, like you had talked about being very clear. Do you need to say these are the uses in the actual screen to click through rather than sending them off to the privacy policy?
The question is whether a link alone in a click-through agreement is enough, or whether you want to have actually the words and everything, right there on the page that they're agreeing to. And the question is, there's not an explicit answer. So the law doesn't require you to have the language on the page versus saying links are not acceptable. Just speaking in the U.S. alone, there has been case law that has shown that a click-through agreement with a link is enough to create a contractual obligation. Whether that's going to be enough under the GDPR to obtain consent that complies with all the different, informed and unambiguous requirements, I guess ultimately remains to be seen. If you can do it in an easy, unobstructive, unobtrusive way to even give the highlights as this is what you're agreeing to, and this is how we're using the information, and you just provide that, so maybe just a subset of your privacy policy on that consent form in addition to a link. That might be one way. Essentially, reasonable and defensible is what we preach. So if all you can do is a link, if that's what you have now, you're definitely ahead of the game from a lot of people that aren't doing anything. right? The more you can go to show that you're really being explicit of how you're obtaining consent, the better position you're going to be in, not even from a regulatory perspective, but also from just a marketing perspective. When you're looking to do business in this realm, when you're looking to attract different customers, different vendors, right, to do business with you, the more you can point to say, look, we go out of our way to comply, and this is how we do it, the better position you're going to be in ultimately.
If we're storing some information with, say, this data storage, and then they have a breach, and we've linked that in our privacy policy that we're using them to store data, do we need to tell our customers that they have a breach, or is that already covered?
So the question is, if we're using, say, Amazon Web Services, big third-party cloud provider, and we're storing all of our personal information with them, and they suffer a breach, do we have an obligation to notify our customers, or is the obligation with them? The obligation is still with you. So in the event that you are the controller of that information, the obligation is on you to notify the customers. Now, and this is a situation that we've seen, this is probably more of the incident response that we handle at the firm is for vendors of our clients than for the actual clients themselves. So these exact situations, but it's on the vendors at the end of the day under almost every breach notification law, or under the whoever controls that information, the data controller. It's on them to notify the end user customer. Hopefully in those agreements that you have with the cloud service provider, they have some type of indemnification obligation where they'll pay for your costs for notification, right? So then, when we talk about reviewing contracts, that's definitely a key piece. Of course, the bigger the provider, the less leverage you're likely going to have in negotiating those. Some of the big ones are, fairly good with, offering some of those terms and conditions, but definitely worth reviewing what those terms are and including that in your analysis when you're comparing with different cloud service providers.
Is there any threshold on how accessible data needs to be? So, for example, if it's in cold storage, a tape backup, delete request, because it's in a highly inaccessible, does that absolve you of deletion? I guess that also extends to a third-party provider who's an email provider, and they have logs of clicks and opens, those kinds of things. What is the burden on those things?
So it's a great question. The question is with respect to what are your obligations to comply with stuff, and this kind of ties in with your previous question and stuff that you may have in cold storage, right? Stuff that you've been collecting for years now that you just have sitting there. How far do you have to go to comply with the right to be forgotten, for example? And the answer to that is not explicitly clear. So that there's no hard and fast rule that differentiates between the processing and storage of data prior to the law compared to after the law. It just deals with the processing of data. So in that sense, it doesn't give you a free pass if you've already stored that information, right? It also does not differentiate between stuff that's currently on our systems versus stuff that's residing on a tape backup, right? Now the level that you have to go through to bring up those old records and purge potentially the all European data that might be on there. Well, a couple things. One, I would say just have some type of data retention policy in place. Just have an understanding that if you're going to be storing that information, why? Do you really have a need for that information? If you don't really have a need for it, get rid of it because it's doing you no favor sitting in cold storage, right? Another one is if someone explicitly comes and asks you, under this right to be forgotten, says, I want you to get rid of my information, and you say, well, that was just too hard to go with the tape backups and delete. Now you're in more of a gray area as to whether or not that's going to be compliant, right? At the end of the day, are the biggest risks here in those types of situations? Probably not. Remains to be seen how aggressive data privacy rights groups get with respect to encouraging the government to go after people enforcing these. We'll just have to wait and see, right? So if the question is, do I spend my money trying to comply and get up to speed with what we can do going forward versus spending all the money, on limited resources on stuff that we did in the past? Let's be realistic about, what our budgets are, what our capabilities are. Let's do what we can. Let's put ourselves in the best reasonable, defensible position rather than Trying to deal with those more esoteric examples. Not to say that they don't apply, because they probably still apply. So the question is, there was a great definition for personal data that was provided in the regulation, and is there also equal definitions for data processing? And the answer is yes. So the regulations do define both processor and controller, and they define what those instances are. And I don't know those. I don't know the specific definitions offhand, but they are in the regulations. Essentially, if you are the one that's collecting the information from the end user, you are very likely going to be the controller of that information. And what you do from that, every other, you have a customer, you get their information because you're going to ship them a product or provide them a service, and you use a third party to process their credit card. That credit card processor is going to be the processor, right? The cloud storage provider is going to be a processor. All your vendors that might be touching and feeling that data from you, they're going to be the processor. And in the case that you are the processor, well, then that's the lowest level you go. There's no level beyond that. Mm-hmm.
In the case of using a third party where we're providing some type of information that will scrape the rest of that person, who owns that information?
So the question is, if we provide a third-party vendor with some of our own information, and that third-party vendor then goes and scrapes some of their own additional information, say about the same individual, who owns that information? The answer would likely be that you only own what you provided. You would not obtain any ownership of that additional information just by the mere fact that they obtained it. Now, your liability with respect to that information would also parallel that, right? So if they scrape data that they append on to your information, absent some other contractual arrangement that you have, you would not necessarily be liable for their handling of that information, right? Because that would be outside of the scope of what you can control.
How does the right to be forgotten work if your basis for collecting information is something other than consent? So if it's like legal obligation and legitimate interest, how does that work?
So the question is, how does the right to be forgotten jive with one of these areas, one of these legal bases for collecting the information outside of consent? So consent is easy, right? Either they give the consent or they didn't. Either they've withdrawn it or they have not, right? And the answer is, really, it comes back to tying the purpose of the collection with respect to how you are processing their data. So if you're collecting data under the vital interest category and it's a life or death scenario, and you're on your way, let's say to the hospital, and you're a medical provider, and the guy says, please, I want to be forgotten, get me out of the system. Well, you're going to be able to override that to some extent, right? Now, if you've collected information under one of the public authority exceptions or bases, right, and you are now want to use that information for some type of commercial marketing purpose, well, then certainly the right to be forgotten is going to apply to you, and as is the consent rule, right, because you are now outside the scope of the purpose you collected. So once you tie in the purpose, it almost takes care of itself in a lot of instances, because any other use of that data outside of the purpose really needs to be disclosed, and you have to determine whether or not that was allowed under the reason that the data was collected in the first place.
Now, with the GDPR, is there, I believe there's provisions that you're operating under like other legal obligations, right?
Mm-hmm.
So, like I know in the U.S. there's FERPA, right?
Mm-hmm.
Educational records.
Yes.
So it says, get rid of my records here. I no longer roll. School says, hey, I have to comply with FERPA.
Right. Yes.
Similar, I guess the same would apply if you're operating in Europe, I guess.
Right. That's exactly right. Yes. So the question is, if you have some type of legal basis for collecting the information that applies to some other law. So in the U.S., we have FERPA, which is this educational system, governs the collection of data, processing of data with respect to educational systems. Are there similar exceptions within Europe that are built in? Now, with respect to similar obligations or similar regulations in Europe, that would probably be country specific with respect to how they handle the data, and that's not something I'm intimately familiar with country by country. Parallels to something like FERPA or something like HIPAA in Europe. If it comes to the U.S. or Canada, if let's say that under one of those regulations you are collecting data that's also governed under one of the U.S. or Canadian regulations. So let's say you have a European resident attending your school, right, and that information is now governed under FERPA. Yes, we would look to apply that exception to the collection practices to that information, right? But again, that's now going to be limited to use of that data solely in compliance with that regulation and not beyond that. Mm-hmm. Hmm. Mm-hmm. So a question is with respect to homes, and if we collect information, let's say about the price of homes, what homes might be listed for on the market, should we be obtaining consent from all the individuals that are providing us with that information? And that's a great question. So is the price of a home alone enough to be considered personally identifiable under the regulation? I would want to look closer at that and look into what other information you might be tying with that. Now, I think on its face, it would appear that a home price and a home value alone might not be enough to trigger. But if you have other information inside that same database, let's say if this is easily cross-referenced with the local property records that do publicly display that information, could a case be made that now you fall under the realm of personal information under GDPR? Potentially. So I think that analysis needs to be done kind of case by case. What information you're collecting and how is it stored together with other information, and can that collection be used to potentially identify someone? That's the analysis you want to do in the creation of your data map in your internal audit situation to find out, should we be obtaining consent? Are we okay with not obtaining consent?
I think we should probably give Brandon a break because he's got a lot more. Probably needs to sit down and have a bite.
That'd be great.
Are you
Yeah, I'll be sticking around. So, yep, anyone wants to stick around after for questions, I'll be here for a while.